Hi, everyone. Welcome to our Thursday lives. Lorraine DeLessio, Lorraine the lawyer, here with DeLessio Law Group. And I am so excited today as we are joined by attorney Luiza Millar, a senior attorney with particular expertise in all things marriage sponsorship when it comes to U.S. immigration. I have the honor and privilege of working with Luiza at DeLessio Law Group, and today we're going to take you through some of the key ABCs of marriage green card cases. What are these cases? What are some of the basic issues that you need to be thinking about, and as we move forward. So let's start off. So Luiza, welcome. Thank you for coming today.
Lorraine, thank you so much for having me here today. I am happy to be part of the DeLessio team, and I'm happy to be here live with you today.
Thank you. We are so thrilled. Luiza, perhaps you could explain generally for us, what is a marriage green card?
A marriage green card is an application, a benefit that can be obtained from the U.S. government, legal permanent residency based on marriage to a U.S. citizen or a permanent resident.
Excellent. And how long typically does it take to process a marriage green card application? I'm assuming that timeline must fluctuate, but generally speaking, what could you be looking at?
If the applicant is in the United States and is eligible to apply for a green card in the US, the estimated time is between a year to a year and a half. If the applicant is abroad, the time is longer, could be 2 years, sometimes more, depending on the availability of an appointment at the US consulate in the applicant's country of application.
Oh, excellent. Okay, thank you. And what kind of documents do you need to be thinking about when you're looking to file or work with an attorney to file a green card case through marriage?
Usually when you apply for a green card based on marriage, you have to show both spouses will have to show that they are free to marry. So usually if they have been married in the past, we would like to see the divorce decrees, we would like to see the death certificates or annulment certificates. Then we would need to look at the marriage certificate to show that the relationship exists, and then documentation confirming that the relationship is real, is bona fide, as we would say.
Okay. Why is it that there's a concern that we need to show that a marriage is a bona fide marriage? Why is that for something that U.S. immigration wants to address in these applications?
The green card based on marriage is a very important benefit that the U.S. government awards citizens coming from other countries. So when the marriage is the basis of such application, the government wants to make sure that the relationship is real, that the couple lives together, that they do things together, that they are going to be here together.
Is there much fraud in this area? Is there much misrepresentation that occurs on these applications?
It does. There is fraud that can come up in the applications. There are people who think that getting married is an easy way to go about getting the green card. This is why the officers, whenever they invite the applicants at the interview, they discuss the details of the marriage, they discuss the documentation that's being forwarded to detect any kind of situation that fraud could happen. So, for example, if when you go to an interview, the applicants cannot communicate with each other, that raises a lot of questions. If the applicants do not know anything about each other, or they know very little, or they do not know how to answer questions about each other, that again raises a lot of questions in the officer's mind with respect to the validity of their marriage.
So it's perhaps kind of a weeding out process that question is addressed, is if they can show a good faith, bona fide marriage, then perhaps, is that right?
That is correct. The officer is not there to get you, but the officer is there to determine that the relationship is actually real.
Okay. Excellent. Thank you so much, Luiza. May I ask, are there income requirements for a marriage visa?
Yes. Thank you for the question, Lorraine. Yes, there are requirements for the visa for the financial ability of the sponsor to be able, of the spouse, the U.S. citizen or resident, to support the beneficiary here in the United States. Usually, the U.S. government has a minimum guideline. It's called the poverty guidelines, by which they determine the petitioner's eligibility to support their spouse in the U.S. And the guidelines are based on the amount of people or the number of members of family in the household at the time of the application.
Interesting. And is there an affidavit of support, or is there a mechanism to allow someone, if they might not fit the income requirement, that they could perhaps have another individual join the application so that they can, meet that minimum requirement?
Yes. So usually when the petitioner submits documentation for the applicant, the petitioner has to show that they have the minimum annual income necessary to support the beneficiary. However, if the petitioner does not meet the minimum income requirement, the petitioner can supplement with assets, or if there are no assets or the assets are not sufficient, it is possible to bring into the case a co-sponsor, somebody else who is a U.S. Citizen or a resident, somebody else who has legal status to work in the U.S. and who can provide the same information that the main sponsor would show: personal income, assets, or any other documentation that will show that they can support the applicant without asking for government help.
Okay, interesting. And then what are the medical exams? What is that part of the application, and at what part, in the sequence of the timing, does that typically kick in?
The medical exam is an important step, an important part of the green card application. Depending on where the applicant is at the time, the medical exam could be submitted initially with the application, or it could be submitted right before the interview. So, for example, if the applicant is in the United States, the applicant has the option of submitting their medical exam at the beginning of the application or at a later time when the USCIS officer requests that medical exam. However, this is a requirement everybody has to meet, and this is to provide safety to the population of the United States. The medical exam is there to show that the applicant coming to the US does not present a health risk to the general public.
Interesting, very interesting. And if there is something emergency that happens in your life while you're processing the a spousal marriage case for a green card, what is the possibility of being able to request an emergency travel document of some kind? Or is there a possibility?
That is a very good question. So when somebody is applying for adjustment of status for green card in the United States, they are supposed to apply for a travel document. However, at this time, the travel documents take quite a bit of time. The regular processing time right now, it's about a year. However, if there is an emergency and the applicant has to depart the US, there is a way to request an appointment with the local USCIS office, present evidence of the hardship and emergency to depart the US. Usually, the emergency consists of medical reasons, death in the family, extreme circumstances that are not work related. So there are personal circumstances that would render somebody to leave the country, leave the country right away.
Oh, okay. And have you had to deal with a situation like that where, and especially with the pandemic, have you seen that come up?
So whenever we call USCIS to request an emergency appointment, the officer will ask us if we have evidence of a medical emergency or a family emergency. The appointment would not work for business emergencies.
Mm-hmm. Mm. Right.
And usually the process is, we would call immigration. The officer will put us in a queue, will place us in a queue with another officer to call us back and set up an appointment for us. Usually the appointment happens within 1 to 2 weeks. And at the time of the appointment, the applicant will have to go in person and bring the evidence showing the emergency to depart the US.
Okay. Okay. This is wonderful. Well, thank you so very much for all of this information. And is it, would you say that from the time that you get the travel document and also work authorization to the point that you actually get your green card in hand, are there things that is that a fairly long period right now that you're waiting for? And is there also things that you should think about that you should be doing during that time as well?
At this time, the estimated processing time for a work permit or a travel document is approximately 12 months. The green card application itself could take up to a year and a half. So it is possible there is a gap in between the two timelines. However, once the work permit is approved, the applicant can start working right away anywhere. And once the travel document is approved, the applicant can leave the country while the green card application is in process.
Okay. Okay. Interesting. All right. And I think, just one last question perhaps is, there is, of course, an interview for the initial filing, because I understand there are 2 stages of the filing on a marriage case. One, and then another one in about 2 years and 8 months is down the line. And for that initial interview, would it be recommended to have an attorney along with you?
It is recommended to have an attorney with you to give you the confidence to move forward with the interview and be able to answer all the questions without having any worry that the officer does not properly understand what you would like to show. However, the attorney is not allowed to answer questions of fact. The attorney's purpose in the interview is to ensure that the interview runs smoothly.
Okay, excellent. All right. And, between those 2 interviews, the first one and the one, about 3 years down the line, why is it necessary to have another interview 3 years down the line? And what kind of documents should you think about collecting and preparing for that second interview?
For this question, I'm going to take a step back just a little bit
Of course.
to explain the process. So when a couple gets married and they apply for the adjustment of status for the green card in the US, if the approval of the green card comes before the second anniversary of the marriage, the green card is going to be conditional and it's going to have a validity of 2 years. In order to obtain the permanent resident card, the 10-year card, there is a second application, an I-751 application, which is called removal of conditions on residence. This application sometimes can take 8 months, sometimes can take 2 years. Usually it does not come with an interview. However, if there is one, the applicant will have to show up. For the second interview, just like with the first one, the applicant will have to show the bona fide character of the marriage, based on which he or she obtained a residency in the first place. And usually the type of documents that the immigration officer is looking at is, for example, tax returns, joint bank accounts, pictures together, children born into the marriage, insurance together, any kind of documents demonstrating that the applicant, the beneficiary, resided and had a good faith relationship with the petitioner, with whom on whose basis obtained the residency in the first place.
Okay. Oh, Wonderful. Well, thank you so much for explaining this.